The moment an offense is reported, the Indian criminal justice system moves down one of two strictly separated pathways. The Bharatiya Nagarik Suraksha Sanhita, 2023, is the code that governs this procedural diversion. This classification determines the level of autonomy a police officer has, whether they can act on their own initiative or must wait for a judicial order. Understanding the boundaries of police authority requires a close look at Sections 2G and 2O of the BNSS. While the statute provides the raw power to investigate, 6 landmark Supreme Court judgments establish the rules for how that power is actually used. This distinction serves as the mechanical implementation of Article 21, the constitutional protection of a citizen's life and personal liberty. Under BNSS Section 2G, a cognizable offense activates 2 specific legal powers: the authority to arrest without a warrant and the ability to begin an investigation suo motu.
This pathway is reserved for crimes like murder, rape, and kidnapping, offenses where the nature of the crime requires immediate state intervention. In these cases, the police do not need prior permission from a magistrate to begin gathering evidence or to take a suspect into custody. Section 2O defines non-cognizable offenses. Here, the authority to arrest and investigate is restricted by default. This applies to minor wrongs and private disputes, such as defamation or public nuisance, where the direct threat to society is lower. Under 2O, a police officer has no authority to arrest a suspect unless they first obtain a warrant from a court. The investigation is effectively paused until a magistrate reviews the information and issues an order to proceed. The classification scales the state's power based on the offense. Serious threats allow for autonomous police action, while minor disputes require judicial oversight. This logic is applied the moment a citizen enters a police station to report a crime. For a non-cognizable offense, the police record the details in a station diary, producing a non-cognizable report, or NCR. The NCR serves as a record, but police generally advise the informant to see a magistrate, preventing state interference in minor disputes. If the information discloses a cognizable offense, the police are legally required to register a First Information Report, or FIR. The Supreme Court addressed the importance of this step in Lalita Kumari v. Government of Uttar Pradesh. The court ruled that registration of an FIR is mandatory whenever a cognizable offense is disclosed. Preliminary inquiries are only permitted in rare, specific categories. Any delay in registering the FIR must be justified by the authorities to ensure the victim's access to the justice system is not blocked. In cognizable cases, the FIR acts as the legal trigger that compels the police machinery to begin its work. Once an FIR is registered for a 2G offense, the police can exercise significant authority over the situation. In H.N. Rishbud v. State of Delhi, the Supreme Court defined the specific stages of this autonomous investigation. This includes proceeding to the spot, collecting evidence, examining witnesses, and making arrests where necessary. These actions, searching a location or interrogating a suspect, do not require a magistrate's prior approval. To prevent the misuse of these powers, the judiciary maintains a role as a constitutional overseer. The ruling in State of Haryana v. Bajanlal established the limits of this power. The principle is clear. While police powers in cognizable cases are wide, they are always subject to judicial review. If an investigation is found to be an abuse of the legal process, the High Court has the jurisdiction to quash the proceedings entirely. The authority to investigate is not absolute. It is constrained by the ability of the courts to intervene if that authority is misapplied. The authority to arrest without a warrant is the most significant power granted under Section 2G. This power is governed by the rules set in Joginder Kumar v. State of Uttar Pradesh. The court held that a police officer is not obligated to arrest a person simply because it is lawful to do so. The arrest must be justified and necessary. The court further addressed the misuse of arrest in Arnesh Kumar v. State of Bihar. This judgment requires police to record written reasons for an arrest, which a magistrate must then independently examine. A final set of protections was established in D.K. Basu v. State of West Bengal. These safeguards include the mandatory preparation of an arrest memo, the right to inform a relative, and the requirement for a medical examination. Together, these 3 cases ensure that a warrantless arrest is a documented, procedurally regulated act rather than an automatic response. Sections 2G and 2O of the BNSS provide the structure for how the state balances public safety with individual liberty. Cognizable classifications prioritize rapid action to address severe threats to the community. Non-cognizable classifications prioritize judicial gatekeeping to prevent unnecessary interference in minor disputes. The BNSS provides the mechanism for enforcement, but the Supreme Court's guidelines provide the procedural checks required by Article 21. Examining the interplay between these statutory definitions and constitutional safeguards, we see a system designed to maintain order through regulated application of law.